Welcome to the deep dive. Imagine taking centuries of heavy traditional human judgment and just dropping a humming, data-hungry artificial intelligence server right next to the judge's bench.
Yeah, that instantly creates a massive legal labyrinth.
Right, because you have this physical environment built on precedent, dusty stacks of paper and really deliberate, slow human consideration. And it's colliding head on with a technology entirely designed to process massive amounts of information at lightning speed.
Exactly. And that collision is exactly what we're looking at today. We have a fascinating set of notes and excerpts compiled by an author named Navi.
And these notes detail the Supreme Court of India's suggested AI regulations for the judiciary, right?
Yes, they do. And our mission today for everyone listening is to uncover how the legal system plans to legally protect itself from the massive AI tools it is starting to adopt.
Because figuring out how you regulate the robot that helps the judge is turning out to be, well, one of the most complicated paradoxes in modern law.
Oh, the complexity of that paradox really cannot be overstated. I mean, if we look at the foundation of these suggested regulations, specifically Chapter 7, Section 48.
Right, which focuses on data protection and cybersecurity.
Exactly. We see regulators immediately colliding with reality. Because this AI, it can't just operate in a legal vacuum.
It has to comply with the rules that already
The
exist.
two massive pre-existing frameworks, actually. On one side, you have the Information Technology Act of 2000, known as the ITA 2000.
Which basically governs the non-personal data that AI touches.
Right. And on the other side, there is the Digital Personal Data Protection Act of 2023, the DPDPA 2023, and that aggressively governs all personal data.
Okay, let's unpack this for you listening, because trying to satisfy both of those frameworks simultaneously is just wild. It's like the judiciary bought a brand new, highly advanced sports car. That's the AI.
I like that analogy.
Yeah, and before they can drive it in the courtroom, they have to prove it passes both the old emissions tests from the ITA 2000 and the brand new safety standards from the DPDPA 2023.
That is a great way to look at it. Throwing an AI into the middle of those two distinct eras of law is basically a recipe for instant paralysis.
Right, because the machine has to satisfy the old guard and the new guard at the exact same time. And to pass these, safety standards, the regulators had to invent a completely new legal concept.
They did. Because the data flowing through a courtroom isn't like data flowing through a social media app or an online shoe store.
The consequences of a leak are just entirely different.
Completely different. So the authors of these guidelines coined a specific term for this unique environment. They called it sensitive judicial data.
Okay, so what actually qualifies as sensitive judicial data? Because if we are going to look at the rules surrounding this, we have to know exactly what kind of information is being fed into the machine.
Well, according to Navi's breakdown of the regulations, sensitive judicial data includes the obvious elements. So, any personally identifiable information of the parties involved in a case, the witnesses, or the legal representatives.
That makes total sense. But doesn't the definition expand significantly when it comes to the concept of harm?
It does, yeah. The text states that sensitive data includes any processed information where unauthorized disclosure causes harm.
And the way they define harm in relation to AI incidents is incredibly specific, isn't it?
Very specific. It covers physical or financial damage, which is standard, but it explicitly includes damage to the reputation or the rights of an individual, an institution, or even infrastructure.
Wait, let me challenge that definition of harm for a second. Because including damage to reputation or rights seems to cast an unimaginably wide net. Isn't practically all court data sensitive under that umbrella?
It is a massive net, yes.
Because think about the fundamental difference between a parking ticket dispute and a high-stakes corporate embezzlement trial. A leaked parking ticket might not cause anyone physical or financial ruin, but if it becomes public, it could absolutely damage someone's reputation or affect their rights.
Oh, absolutely. You really could.
So if reputation is the standard, it sounds like almost every single piece of paper filed in a courthouse gets caught in this net.
Well, the mechanism behind that broad definition is actually very intentional. What's fascinating here is that the regulators are acknowledging a unique danger inherent to artificial intelligence.
You mean hallucinations?
Exactly, hallucinations. In a judicial context, if an AI is processing documents and it hallucinates a false connection.
Like, say it statistically links a witness in a minor civil dispute to a major criminal precedent.
Right. That false output doesn't just crash a software program. If that hallucinated document leaks or is mistakenly entered into the public record, it can destroy a person's life.
It could derail a career or completely invalidate a legal precedent.
Exactly, because reputation is often the primary currency in the legal system.
Wow. So because the definition of what constitutes sensitive data is so massive, giving the AI unchecked access to the archives is far too risky.
Way too risky. The courts are essentially forced to drastically restrict how the machine operates.
Which leads directly to the strict guidelines in Chapter 7. The source material outlines what are basically 5 commandments, or rules of engagement, for the AI.
Yes, and instead of just listing them out, let's trace the actual journey of a piece of evidence as it interacts with the AI.
Okay, so before the machine is even allowed to look at a single file, the courts have to prep the data, right?
I do. And that preparation involves 2 critical principles: data minimization and anonymization.
Let's start with data minimization.
The regulations state that when selecting and deploying these systems, the courts must prefer the AI that requires the least amount of personal data to achieve its goal.
And this is explicitly noted as being vital in matters concerning personal liberty, right?
Exactly. Furthermore, before any data is used to train, test, or refine the AI, it must be anonymized. That is the anonymization principle.
So if the AI is a contractor you hired to fix a very specific plumbing leak in your bathroom, data minimization means you only hand them the key to that one bathroom door.
I love that analogy, yeah.
You do not give them the master key to your entire house, letting them wander through your bedrooms and closets, especially if your personal liberty is locked inside one of those rooms. You give the machine only what it needs to execute the task.
The underlying logic there is completely about limiting exposure. However, the text includes a very pragmatic caveat regarding anonymization.
What's the caveat?
It mandates anonymization only to the extent technically feasible, without compromising the utility of the data.
Oh, I see. Because if you redact every single name, date, location, and specific action from a court document, the AI can't contextualize the legal argument.
Exactly. It loses its ability to assist the judge at all. So the regulators are trying to mandate a delicate balance between absolute privacy and actual utility.
Okay, so the data is minimized, it is anonymized as much as possible, and now the AI is actively processing it. This is where we get to the actual handling of the data. The regulations mandate strict authorization and safeguards.
Right. The text dictates that sensitive judicial data cannot be transferred to any external system without express written authorization.
From the appropriate authority, as they call it.
Yes. The mechanism here is designed to prevent automated, invisible data sharing.
So an AI system can't just independently decide to dump court records into a third-party cloud server just because it finds a faster processing speed.
No, definitely not. An actual human being with designated legal authority has to sign off on that transfer in writing.
And even with that signature, the transfer must be wrapped in heavy technical and contractual safeguards.
Yes. And when they say contractual safeguards, that is crucial. We aren't just talking about encrypting the file.
We are talking about binding the software vendor in legally ironclad agreements regarding unauthorized access, disclosure, or misuse.
Precisely. You are tying the tech company's legal liability directly to the security of the court's data.
Makes total sense. Which brings us to the final phase of the AI's life cycle in the court: ongoing oversight.
Right. Mandatory cybersecurity audits. Every AI system used in court processes has to be audited at least once a year.
Or potentially more frequently if directed by a body called the AI Secretariat, right?
Yes. And the outcomes of these checks must be reported to the appropriate authority and logged in an AI register.
So it is a permanent, mandated cycle of scrutinizing the machine. This sounds incredibly robust.
It is incredibly robust.
But here is where it gets really interesting. By building this fortress and by officially declaring this massive ocean of information as highly sensitive judicial data, the courts have accidentally walked themselves straight into a massive legal trap regarding the DPDPA 2023.
This is the core paradox that the author Nayavi highlights in these notes, and it is absolutely fascinating to watch it unfold.
Let's connect this to the bigger picture for you listening. The Digital Personal Data Protection Act of 2023 was primarily designed to regulate big tech companies, social media platforms, and data brokers.
Yes, exactly. And interestingly, the DPDPA itself does not actually define the term sensitive data.
But wait, really, it doesn't define it at all.
No, it doesn't. But what it does do is define a very specific, heavily regulated legal entity known as a significant data fiduciary.
Okay, and what is a significant data fiduciary?
The law defines it as an entity that handles large volumes of sensitive data.
Oh, wow. I see where this is going. The DPDPA doesn't define what sensitive data is, but it heavily regulates anyone who handles it.
You got it.
So, by the courts writing their own internal AI rules, raising their hands, and officially classifying their own files as sensitive judicial data, they have accidentally volunteered themselves for massive regulation.
Yes. The logic completely loops back on itself.
Because the judicial system handles this newly defined sensitive judicial data, and because the use of AI fundamentally requires processing massive amounts of it, the judicial authorities automatically transform into significant data fiduciaries under the national privacy law.
The irony is unavoidable. The courts are supposed to be interpreting and enforcing the privacy laws for everyday citizens and corporations.
And suddenly they find themselves caught in the crosshairs of their own enforcement mechanisms.
Right.
It's like a highly skilled trauma surgeon being forced to halt an operation to fill out a 50-page privacy compliance audit every single time they ask the nurse to hand them a scalpel.
That is exactly what it's like.
I mean, how is a court system supposed to function? How can it deliver swift justice or clear a massive backlog of cases if every time a judge uses an AI tool to summarize a brief, the court is bogged down by the intense, heavy compliance requirements of a significant data fiduciary?
Well, it creates a state of administrative paralysis. You cannot have the highest courts in the country paralyzed by data compliance checklists intended for social media companies.
Right. It just doesn't work.
No. And this friction between state function and individual privacy is why lawmakers build exemptions into privacy laws.
Ah, the escape hatch.
Right. The source material spends a lot of time analyzing how the courts might try to use Section 17 of the DPDPA 2023 to escape this trap.
Let's look at how they might try to get out of this. What are the options under Section 17?
The notes break down two potential avenues, but neither is a simple fix. The first is Section 17 sub 1.
Which is a partial exemption, right?
Yes, it allows an entity to bypass certain obligations. Things like establishing a legal basis for data processing, dealing with the rights of data principals, and managing cross-border data transfers.
So a partial exemption clears out some of the bureaucratic underbrush.
It does, but Navi points out a fatal flaw for the courts if they rely only on this partial exemption. Section 17 sub 1 explicitly excludes an obligation under Section 8 sub 5 of the Act.
And what is Section 8 sub 5?
It is the core mandate that requires a fiduciary to maintain reasonable security practices.
Oh, I see. So even with the partial exemption, the courts remain legally liable for security breaches under the DPDPA.
Precisely. They are still legally on the hook.
Which means they are still stuck in the regulatory trap, just in a slightly different corner of it.
Exactly. So if the partial exemption doesn't free them from liability, what is the alternative?
Right. What is the alternative?
The alternative is Section 17 sub 2. This is the nuclear option. A complete and total exemption from the DPDPA 2023.
Wow. A complete exemption. But a court cannot simply declare themselves exempt, can they?
No, they can't. Under the law, they would have to be explicitly notified by the central government as instrumentalities of state.
Okay, instrumentalities of state, and there is another condition too, isn't there?
Yes. Furthermore, to qualify for this total exemption, the purpose of their data processing, meaning their use of the AI, would have to be officially classified under the banner of maintaining public order.
Wait, maintaining public order? Stretching the definition of public order to cover routine AI court administration seems like a massive legal reach.
It is definitely a stretch.
Because public order usually brings to mind things like preventing riots, national security threats, or counterterrorism, not a judge using an algorithm to organize evidence in a civil dispute.
No, it is quite a leap. But this is exactly where the author Naadi proposes a final solution to this entire paradox.
Right, the proposed fix from the text. What is the suggestion?
To bypass the contradiction of the courts regulating themselves as significant data fiduciaries, Navi suggests that the Ministry of Electronics and Information Technology, known as MAIDI, should simply step in.
And formally declare the court systems as completely exempted under Section 17 sub 2.
Exactly.
Now, before we dive into the implications of that fix, it is incredibly important to note here that we aren't endorsing this view. We aren't taking a political stance on what the government should or shouldn't do regarding these exemptions.
No, absolutely not.
We are simply unpacking the potential solution that the author lays out in the source material to resolve this legal gridlock.
Right. And looking at it purely from a functional standpoint, you can understand why the author suggests it.
Because the DPDPA was written for tech companies, not for the sovereign functions of a judiciary trying to modernize an overloaded system.
Yes. From a bureaucratic perspective, having Mady grant a Section 17 Sub 2 exemption is the cleanest way to cut the Gordian knot. It allows the courts to actually use the AI without drowning in compliance paperwork.
So the ultimate fix to the headache of regulating AI in the courtroom is just to have the government declare that the courtroom is exempt from the data privacy rules entirely.
Pretty much, yeah.
But the philosophical tension that creates is just wild. Let's summarize this journey for everyone listening.
Quite a journey.
We started this deep dive looking at a genuine, good faith effort to safely integrate AI into the legal system. We saw regulators lay down strict rules to protect sensitive judicial data.
Right.
But because those rules were so robust, they accidentally classified the courts as heavily regulated data fiduciaries.
Exactly.
And to fix that problem, the proposed solution is to just have a government ministry grant the courts a magic hall pass, exempting them entirely from the national privacy law.
It is the ultimate example of legacy legal frameworks buckling under the weight of emerging technology.
Yeah, the intention to protect the data inadvertently makes utilizing the technology legally impossible without a massive loophole.
Which leads us to a profound question about the future of these laws.
Right.
A final thought for the listener to chew on.
Yeah, let's hear it.
If Mady does follow this suggestion and grants the court systems a complete exemption under Section 17 Sub 2, just so they can use AI smoothly, what happens to the underlying philosophy of the DPDPA 2023?
That is the big question. Does this set a legal precedent?
If the ultimate protector of citizens' rights, the judiciary, is completely exempt from the rules protecting citizens' personal digital data from AI, who holds the ultimate AI referee accountable?
Who guards the guards in the age of artificial intelligence? Because if the referee opts out of the rules, what stops a giant tech conglomerate or a massive social media platform from pointing to that exact same loophole and lobbying for their own public order exemption?
It is definitely something to seriously consider as these AI systems become permanently embedded in the institutions that govern us.
Absolutely. Well, thank you for joining us on this deep dive today. Keep questioning the systems being built around you, and we'll see you next time.